Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law. And casual listeners who have to deal with consolidated industries and privacy preferences in their everyday lives and want to understand how the law looks at them. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Mergers and Acquisitions Committee of the Antitrust Law section, and is part of our ongoing Mergernomics series that examines the tests, tools, and analyses used by antitrust economists to analyze mergers. Today's episode is on killer acquisitions. The term killer acquisition refers to a strategy by a dominant firm to take out a competitive threat by buying them. We hear the term leveled a lot in the tech sector as an accusation, where we see a handful of market-dominant firms constantly buying small startups. Sometimes what's described as a killer acquisition can make you scratch your head. Really? That tiny startup? But it's not the size of the acquired company that makes the acquisition a killer as much as the competitive threat it is or has the potential to become. So what exactly are killer acquisitions, and how is this analysis any different from ordinary competitive impact analysis? Joining me today to talk about these issues are Dr. Ethel Fonseca and Daniel Motter. Dr. Ethel Fonseca is a partner in RBB Economics, where she splits her time between the London and Brussels offices. She has extensive experience on merger assessment and particular expertise in the application of quantitative techniques to the evaluation of competition policy issues. Daniel Motter is a senior associate in the global regulatory practice at Hogan Lovells in Washington, D.C. His practice focuses on merger clearance in the technology and consumer sectors. Welcome, Ethel and Danny.
Thanks for having me.
Hey, it's great to be here.
So, Danny, Ethel, killer acquisition is a pretty commonly used term now in antitrust circles. I was surprised when we started collaborating on this episode that it was coined fairly recently. Why don't you kick off your discussion by telling us a little bit about the origin of the term killer acquisition and what it means?
Yeah, absolutely. Happy to start. Well, this terminology actually goes back to work by Cunningham, Ederer, and Ma back in 2021. And it described cases, as you alluded to in your introduction, cases where an incumbent buys a target solely to terminate its development, and in doing so, prevent future competition. Perhaps it might be worth explaining a little bit their research because it puts all of the discussion into context. The research of Cunningham and her co-authors focused on the pharmaceutical sector. And what they found was that the acquired drug pipeline projects, and by that I mean those existing projects but are in very early stages of development, they were significantly less likely to be developed when they overlapped with the acquirer's own existing portfolio, especially when the acquirer had existing market power. And the economics, the economic logic behind this is actually pretty simple. If the target is going to start producing exactly the same drug as the incumbent, then the target is a close competitor. And if the target succeeds, its success will come at the expense of the incumbent's profits. So as long as the incumbent can purchase the target and shut it down for an amount which is less than the value of those lost profits, the killer acquisition makes sense. So you buy the target to kill competition. That's essentially where this all comes from.
It's interesting that this started in pharma because nowadays when we see that killer acquisition label, it's used very casually as the assumed driver of some of these larger big tech acquisitions of nascent, smaller competitors. Do you think that's a fair assessment?
Yeah, that's totally right, Danny. While, as we were just discussing, the term does originate from pharma, it has now, for a long time, for a few years, been linked to the digital sector in the context of these nascent or startup companies. So when you look at the digital sector, the concern tends to be about the early elimination of a potential rival before it can grow into a credible constraint. But this killer acquisition concept may not read across directly from these pharmaceutical matters to this digital world. And this is for just two main reasons. First, because the target innovations in the digital world, they typically are integrated into the acquired systems rather than terminated. And second, I would say there is a lack of a well-defined product innovation pipeline as you have in pharma. And this is because in the digital context, there can be really, really significant uncertainty around what the products and services that the target firm would have produced in the counterfactual, given just how quickly these markets can evolve.
So is it fair to say that this is very much a horizontal concern?
Well, sometimes I would say when the issue is acquiring an actual or a potential competitor, indeed, as you say, very much a horizontal concern. However, if the target is or is expected to be a key input or a source of demand for the rival firm, then non-horizontal concerns may arise. But we can get back to those later if you like.
Yeah, I think that's a great idea. Let's get back to those. But I think first, let's explore the horizontal concerns a bit more. How do you really distinguish between potential competition cases and, your standard horizontal merger analysis?
Well, to be honest, Danny, conceptually, there is no difference. Whether we are looking at a traditional industry or a digital market, a potential competitor is a firm that is outside the acquirer's market today, but maybe in the acquirer's market tomorrow. And so I guess in practical terms, the interesting difference that often arises in the context of the digital segments that we were discussing is the pace at which they move and the uncertainty around how these products evolve. So sometimes a firm is outside the incumbent's market, but they already constrained the incumbent. So for example, if the incumbent is constantly innovating to keep up with the rivals and keep these targets out of the market. But I guess the more controversial and for that reason more interesting case is where a firm is outside the incumbent's market. They do not constrain the incumbent today, but they might do so at some point in the future. And that constraint could arise in the market, the incumbent's market today, where the incumbent is operating, or in the extreme, in a future market, not yet established, where both the incumbent and the target may overlap someday, as I said before, because of how quickly these markets change. So here, the question really is, will this startup grow into this major competitive force in the future? That's a really big no in most cases. And it's just not whether they will succeed, but where? I mean, in which market? And, the difficulty from the economist's perspective, the difficulty of analyzing these cases is a matter of evidence. Do we have enough evidence, enough convincing evidence, or are we all just crystal ball glazing?
Are there some recent cases you can point to that illustrate this analysis?
Yeah. So a couple of cases that come to mind would be, so first, Visa Plat, which was ultimately abandoned. Now, I should say I was not involved, so what I'm going to say is based on what I know from reading about the case. Back then, the DOJ argued that Plat was a nascent threat, and they could challenge Visa's strong presence in online debit. And by strong presence, I mean, I think the DOJ estimated shares of like 70% for Visa at the time. And because Plat was building a competing platform, the merger was seen as a way for Visa to eliminate a future competitor before it matured. And to reach this view, the DOJ seemed to focus on two things. First, internal documents. The view there was that the internal documents were suggesting that Visa was purchasing Plaid as an insurance policy to protect their own business in the US. And Visa had no intention to launch Plaid service once it acquired it. And second, Plaid was considered to be uniquely positioned to challenge Visa's market position because they had a number of connections to US financial institutions. They have millions of consumers. They have consumers with bank accounts in the US, and they were already powering thousands of fintechs. So I think that's a good example of a case in which the acquirer, who was strong, was acquiring a target which was a potential competitor, and according to the regulator, was being acquired to be terminated. I guess another example that comes to mind, which is closer to me because it was investigated by the CMA here in the UK, was the Sabre Fairlogics deal, which was a proposed merger between two US tech and software providers. And they offer technology for airlines. To be more precise, Sabre operates a so-called global distribution system, which essentially distributes airline content to travel agents for the purposes of booking airline tickets. Fairlogics was in a similar segment, but they were smaller. They were considered a disruptive technology provider, and they also enabled airlines to distribute content, but outside these global distribution systems in which Sabre was operating. And I should say that what is perhaps interesting here as well is that even though it has been very much framed as a killer acquisition, it's arguably not your textbook horizontal killer acquisition because of this slight differentiation between the parties, with Fairlogics not active in the global distribution systems sector that Sabre was operating. Now, why do I mention this merger in particular? Because it raises a couple of interesting issues. First one, I would say, is that it shows that low market shares at the point of the merger may not be a sufficient defense in those cases where you have a nascent competitor. And I must admit, I don't have the exact numbers in front of me, but I remember that Fairlogics had a small share back then at the time of the investigation. Regardless of that, the regulators considered that the importance of the competitive constraint imposed by Fairlogics was much better demonstrated by its role in driving Sabre and other global distribution system providers to enhance their offering to airlines. And now, if I may, just to add, in terms of the economic analysis, which is obviously my area of interest, because the airlines typically procure their solutions through a bidding process, the regulators analyzed bidding data to assess the competitive constraint imposed by Fairlogics. So this was done, for example, by the CMA, as I mentioned. And what they looked at was the data, the bidding data, and they concluded that Fairlogics had relatively fewer wins in the years preceding the investigation, and that some of the competitors, small competitors, won tenders despite their limited market position. And interestingly, this supported the parties' arguments that Fairlogic was not an important competitive constraint. However, the CMA concluded that Fairlogic was a key constraint for two reasons. One, it continued to be successful in bidding and gaining these opportunities. And even when they didn't win the contract, just the fact that they were present in these bids led Sabre to offer significantly better terms to the airlines. So in the end, based on quantitative evidence, market feedback, the CMA concluded that Fairlogics was a maverick, a market disruptor, and was pushing this new technology that was imposing a constraint on Sabre. And if I add one more thing, which is really interesting in the context of these nascent deals, the regulators also looked at deal valuation. So what happened back then was Sabre agreed to buy Fairlogics for over $350 million, which was roughly 10 times its revenue at the time and a big multiple of its EBITDA. And the parties back then argued that this premium reflected the expected synergies from integrating Fairlogic's technology into Sabre systems. But the regulators didn't agree with that view, and they considered that this premium was instead based on the value of eliminating this competitive constraint, which would, absent the merger, force Sabre to offer better terms to customers. So all in all, the key pieces of evidence that were used were market shares, bidding analysis, and deal valuation, alongside, obviously, internal documents and market feedback.
Ethel, can I ask you something about deal valuation? Do you think it makes a difference to enforcers whether it's predominantly cash versus stock that is being used for the acquisition? Sometimes a company may find itself with a really high stock price and trying to find some way to almost like an inflated stock price and change it out into something else. Does it make a difference, or are enforcers just looking at total deal value?
Well, in the cases that I've been involved in, there was a lot of emphasis on the actual deal valuation. What is the number that you are buying and what it is that you are paying for? Is there a significant difference between what the company is expected to be worth, which goes back to your point about what is the share value, and what you're paying for it? And if it's a huge multiple, that does tend to raise eyebrows.
Ethel, I think another really interesting note, especially about the Sabre Fairlogics case, is that just days before the CMA blocked this transaction, the U.S. Department of Justice actually lost its merger challenge in federal court. And it really highlights, I think, the difference between the legal standards in the United States and the CMA in Europe more broadly when we're talking about nascent competition, killer acquisitions. There's just a much higher bar in the United States that approving a merger will likely lead to a substantial lessening of competition, as opposed to the realistic prospect of harm in the UK. The court here expressed a significant amount of skepticism that an entity that is not currently competing in the market and is not imminently ready to start competing will become a fully realized competitor in the near future. So I think that leads me to another question here, which is, how do regulators grapple with the more abstract or less certain theories of competition?
Honestly, it's really interesting because my practice is largely CMA and European Commission. And you mentioned the US authorities taking a different stance on Sabre Fairlogic. Even between these two authorities here, we also see a lot of discrepancy, really. And this uncertainty is it's really difficult. To be fair, you see this uncertainty even on cases that are not that difficult to evidence, let alone in cases in the digital sector or the tech sector more generally, where the evidence is just not always there. And I guess one example, which is really old, I must admit, but it's Facebook, Instagram. And I know they are Meta, but I'm old and I still call them Facebook. So this goes back a long time. But the reason why I mentioned this case is because if you think about what the key question is that we are trying to answer in the context of a transaction, we are looking for the counterfactual. What would have happened to the target if he wasn't acquired, right? So the key question here in the Meta Instagram or Facebook Instagram case is, what would Instagram have become absent the transaction? What is the relevant counterfactual? Was Instagram, which, as people may remember, at the time it was just a photo sharing app, was it really a nascent threat to Facebook's social network? Could anyone have predicted this? Or was it only because of the acquisition, and the investments made by Facebook that Instagram became what it is today? So you can see it's just very difficult to predict. And I think that this case is also very relevant for this discussion of killer acquisitions, because it allows us to consider the beneficial aspects of these deals. We obviously been talking about what the concern is, which is you eliminate a competitor, but there are a number of benefits that can come from these acquisitions of nascent or startup companies. From an economics perspective, innovation is a key driver of growth and profitability. But innovation is also very costly and very uncertain. So in many cases, when you have established firm acquiring a startup, this can be pro-competitive because the larger firm can provide capital, distribution networks that are necessary to scale this costly investment. And this obviously can lead to significant efficiencies and a higher chance of this innovation actually reaching, on this point of significant efficiencies reaching consumers. If we go back to the work by Cunningham and her co-authors in Pharma, that drove all this discussion of killer acquisitions, they also found that the prospects of a startup being acquired by a large established company in the future was an important driver of the expected returns to investors. So having this exit strategy might give further incentives for startups to innovate in the first place, which can lead to additional benefits to consumers.
Yeah, I really appreciate that perspective. And I guess before we move on to another topic here, I think highlighting Facebook, Instagram is really important because it shows the evolution of how agencies and really the law has evolved. I mean, back in 2012, I believe the FTC reviewed that transaction. It was announced in April and they cleared it, I think, sometime in August, just a few months later, as opposed to today, the framework is much more robust for reviewing nascent competition, killer acquisitions. And obviously, recent FTC press releases and challenges have said that they view that as an anti-competitive transaction, and it was potentially a mistake for them to allow that to go through. So I think maybe to switch gears a little bit, we hear about reverse killer acquisitions. What is that distinction?
Well, a reverse killer acquisition simply refers to a situation where the incumbent has their own innovation, has their own R&D project, but they abandon it after buying the target that has a competing product. So what is killed here is the incumbent's own innovation effort. One example is Adobe Figma, which was abandoned. And the regulators investigated lots of different things, but of particular interest to our discussion was the market for interactive product design software, which is really the focus of this discussion here. So the story here is Figma had established a substantial share in this market for interactive product design software with its Figma Design product. And Adobe was already present with its Adobe XD, but importantly, was developing a next generation product called Project Spice. Okay, you can see where this is going, right? The commission concluded that Project Spice was intended, this was the European Commission, it was intended to compete more strongly with Figma. And if you look at the commission's press release, the commission noted that transaction would result in the discontinuation of Adobe's existing interactive product design tool, Adobe XD, as well, and I quote, any potential successor product, and thus constituted a so-called reverse killer acquisition. So the reverse killer acquisition concern here was that absent the merger, Adobe would have had the ability and the incentive to continue developing Project Spice, its own product, into a credible rival for Figma. And in reaching these conclusions, the commission relied on market feedback and internal documents. And I should note, interestingly, going back to that point, Danny, that you raised earlier about different authorities reaching different conclusions or approaching things in a slightly different way. In this case, the commission, the CMA, reached the same conclusion as the commission, but they didn't explicitly refer to this as a reverse killer acquisition. They didn't label the transaction in the same way. So you see, if you think about the assessments that we've been discussing of these various deals, very much like your typical horizontal merger, there was an assessment of closeness of competition. But the key issue here is the uncertainty that is associated with the future of these products in question.
And Danny, that also makes me think about the difference, as you said, between how the thinking about this has evolved by enforcers. If you look at Facebook, Instagram versus over a decade later, Meta within, where Meta was considered a potential competitor to this virtual fitness app. I think it goes to this idea that sometimes the big acquiring company may be the one that may have been poised to enter a market, but that the enforcers think is now no longer going to because of these acquisitions.
Absolutely. And I really do agree that that highlights kind of how this has changed, especially when we're thinking about potential competition as opposed to even perceived potential competition, which played a big role in the meta within analysis. Ethel, thinking about what you just said there, it sounds like the toolkit for these nascent cases is quite similar to traditional horizontal mergers, just with a lot more focus on the future. So what are the main questions that an economist and a regulator need to answer to prove harm in these scenarios?
I was thinking about this as we were discussing the preparation for this podcast, and I made a little list in case it helps. So for me, as the economist working on this, the quick questions that I would ask would be, first, how much competition is there already today? How much existing competition do you have? And this would involve looking at whether the acquirer has market power, whether there is an existing competition and buyer power, and whether they are strong enough. Would this entry really be beneficial? Would this new entry be important to customers? I think that's the first point, existing competition in the market today, pre-merger. I think the second point is, does the acquirer remove an important competitor, potential competitor, I should say? So in this case, I would look at, is the threat of entry by the target already constraining the acquirer? Second, how likely is it that the target will actually enter? What is the impact on the acquirer if the target enters? And importantly, how likely is it that others would enter? I think it's important for us to understand that there could be other parties not related to the merger that could still enter and impose an effective constraint on the merged firm. And so the third point would be the deal value, as we discussed before, and importantly, what explains it. So as per our discussion, a high deal value may be considered evidence of removing a strong competitive threat from this potential competitor, but it may well be associated with merger-specific synergies. So allow me to go back to the Facebook, Instagram, because it's true. A lot of people say it was a mistake, but was it? Because you have to remember, hindsight is a beautiful thing. Back then, when you were analyzing the merger, you have to look at the evidence that you have in front of you at the time of the merger, right? And so let me just simplify a bit the whole deal valuation situation, just to make the point here. When Instagram was purchased back in 2012, it was worth $1 billion. And back then, it was less than 2 years old. It had not a lot more than 10 employees. It had a rapidly growing user base, but it made no money. It had zero revenue, okay? Then the following year, that's when advertising started on Instagram. 1 year after, so 2014, we are looking at, Instagram was valued at $35 billion. It was purchased for $1 billion, valued 2014, 35. And then in 2018, so 6 years after, it was purchased by $1 billion. It was worth $100 billion, okay? So how can this be explained? So somebody might say that if you're buying Instagram by $1 billion, 15 employees, no revenue, this must be a cause for concern because you're taking into account the elimination of these threats that will come into the future. But they grew with valuation significantly not too long after they were purchased. So could it be that this is a reflection of significant merger-specific synergies? So I think that's why it is important to look at the evaluation and what is explaining it. It's not the silver bullet. It's one of the important pieces of information.
Thanks, Ethel. That's a really helpful assessment, and I think this is actually a good time to potentially turn to non-horizontal concerns in light of nascent competition. Can you elaborate on that?
Yeah, I think put simply, the concern here is anti-competitive foreclosure. It's the risk of marginalizing rivals and raising barriers to entry. So just to set the scene, non-horizontal mergers, they are generally considered pro-competitive. They typically raise fewer concerns than horizontal mergers. And this is because, first, they don't involve the elimination of a direct competitive constraint, as we have in horizontal mergers. And second, because they often combine products which are economic complements. So these are products that have greater value when they are consumed together. And this can benefit consumers because the demand for these products is interrelated. What do I mean by that? When the price of a product falls and you buy more of that product, because demand is interrelated, these products have better value when they are consumed together. The demand for the other product also increases as a result of the decreasing price. So, as a result, the merger between these complementary products provides the parties with an incentive to decrease prices post merger. So, that's the benefits. And now, if we turn to the digital sector to be more specific, these pro competitive effects of a merger between the established platform and the nascent startup are reinforced by certain features of the digital segment. And these are economies of scope and consumption synergies. I know I'm focusing on the good stuff, Danny, and you asked me to discuss what the anti-competitive concerns are. Bear with me, I'll get there. But I think it is important to understand that there are a lot of benefits that come out of these mergers. So economies of scope, just very briefly, they arise when there are efficiencies from producing two products or services by one single company. So if you have, for example, a search algorithm that you developed for web queries, this algorithm may well be easily used to provide results for users that are looking for ordering food online, or they are looking for certain types of music on a music streaming platform. And the other feature that I mentioned was consumption synergies. And this is when the value the users get from these integrated services. So you can think of this as having, maps and ratings and booking functionality all integrated in one single app. So these features of digital markets can give rise to these efficiencies that we were just discussing. Now, going back to your question, the conglomerate mergers can lead to anti-competitive concerns, in particular in the case of strong network effects or data advantages, again, are features of this digital world. So let me briefly cover the underlying economics of these network effects. The first one, in pretty simple terms, network effects are demand-side scale economies. What does that mean? It means that the larger the network, the more valuable the network is for its users. So where a large established network acquires and integrates a complementary product, that makes that network even better. Its quality goes up with the additional service that they acquired. And if that sounds like an efficiency, that's an efficiency. Now, what is the problem then? The problem is that if the rival networks lose access to this product that was acquired, and if that causes their quality and their customer base to decline, then they may become weaker constraints. They may not be able to impose an effective constraint on the merged entity. And in the extreme, as you may have heard before, the market could tip in favor of this large network. So this means that when a market is characterized by strong network effects, the conglomerate merger is more likely to raise exclusionary concerns of the types that I've just been describing. And just very briefly, an example of this is Microsoft LinkedIn. And the concern here by the European Commission was that Microsoft would pre-install LinkedIn on Windows and integrate it into Microsoft Office, while at the same time limiting the interoperability of other professional social networks with Microsoft's products. So as you can see, the concern here was that this would give an unfair advantage over these rival professional networks. So on the importance of data, which is the second point I wanted to make in the non-horizontal scenario, as you know, many digital platforms, they collect data on their users that they subsequently use as an input to improve their services and improve their products when they are selling to the consumers. What is the problem here? Well, the problem is that when you are acquiring unique data, that can give the platform a significant competitive advantage over its rivals. And in case it's useful to have an example here, the one that I thought about was Apple's acquisition of music recognition app Shazam. And again, if you look at the Commission's concern here, they investigated whether Apple could use Shazam's data to steer users, music fans, away from rivals to Apple Music. How would this take place? So according to the Commission's concern, Shazam's data essentially identified what music users were interested in before they went into a streaming platform. And the concern was that if Apple saw a user of a rival service frequently using Shazam to identify new tracks, it could then send these users personalized notifications, encouraging them to switch to Apple Music. You know, knowing what music they like, you would then get a notification, come listen to this in Apple Music. But what was interesting in this case is that the Commission concluded that the two key criteria for data advantage to lead to anti-competitive concerns, they were not met. And these were, first, the data wasn't sufficiently unique to foreclose the rivals. You know, rivals like Spotify or Deezer, they had access to similar data sets, and they had other ways of tracking user preferences. So that wasn't a problem. The data wasn't unique enough. And the second was that even if Apple used the data to encourage user switching, the Commission determined that the actual impact, the effect on the rivals, would be negligible. And this is because Shazam was not a must-have entry point for these music fans. And the foreclosure strategy just wouldn't allow the merged entity to divert a sufficient number away from these rival music services to the point that they wouldn't have sufficient scale to continue operating in an effective way.
Okay, so Danny, Ethel, trying to put this discussion into the context of some of the other episodes we've done in the Mergernomics series or some of the other analyses that our listeners may be familiar with. The economic analysis you do when it's a quote-unquote killer acquisition, in the horizontal context, is it the competitive harm analysis you do for potential competition, and in the non-horizontal context, is it the economic analysis you do for acquisition of a critical input?
Yes, absolutely. So the economic framework is conceptually the same. There isn't a lot of difference in terms of the analysis that we do. It's more the additional uncertainty that you have and potential competition, as you put it. This is the theory of harm, right? And killer acquisition is sort of the label that the transaction gets attached to the transaction, if you like. But economically, the underlying economics, I would say, is essentially the same as you just described.
So what are your key takeaways here for practitioners?
I also made a list of that because I heard about I heard your previous episodes, and I knew that I would be asked for a list. So I find it helpful actually to summarize. So maybe I will give you my economist view, and then he can add with the lawyer's perspective. I would say I came up with 5 things that we should look at, okay, in terms of assessing killer acquisitions. First of all, investigate why the acquirer needs the target. Seems pretty simple, but is it for efficiency reasons or is it to block its entry? If it's the latter, stop right there. This is just not going to go any further. If it is for efficient reasons, another key takeaway is look at why these efficiencies can't be achieved absent the merger. How can the merger specific efficiencies be substantiated? Another takeaway, consider the counterfactual and put realistic probabilities around alternative events, like the target failing, the target doing nothing, the target being acquired by somebody else and being supercharged into a super competitor, the target entering itself. So there are all these various scenarios that you should look at and attach probabilities to. Another point to look at, establish whether the target is actually a unique or a special threat to the acquirer. We discussed earlier, it is possible that others can come in. It is possible that the target is not special in any way. And finally, map all of this into the deal model, substantiate the deal value, and assess whether this is based on synergies rather than weakening competition. So I think this for me would be the 5 must-dos. So maybe Danny, over to you.
From a lawyer's perspective, the real important thing here is when we think about how these merger investigations are carried out, it's through obviously looking at the economics that you've discussed, but how these theories, how these efficiencies are communicated via internal ordinary course documents. And so to the extent that you hit all of the boxes that Ethel just described, it's vital that you discuss this in your strategy documents and the way that you communicate this merger, both internally, externally. And when we're thinking about document creation, a lot of times people stop at the executive level. When you think about a merger filing, an HSR filing in the United States, you're required to submit certain documents that were transaction related, that relate to competition, that go to the board of directors or an officer. However, just because there's great hygiene at that level doesn't mean that you would not run into antitrust risks down the road in a prolonged merger investigation in which the discovery obligations become more significant. In the United States, if you were to progress past the initial waiting period into a second request investigation, it is very likely that you'll have to produce documents from, say, your sales team, from your procurement team, from a product development team. And it's vital that the communications, the ordinary course documents, the decks that they build reflect what Ethel just spoke about, these positive, pro-competitive efficiencies, and not speculation, and not things that are lacking the proper context about the dynamics of the market or the rationale that the firm has undertaken to go about this merger. And so really, it is important that once the deal is announced, once it becomes safe to communicate this merger more widely within the organization, that you do so in a constructive and thoughtful manner to explain that this is a pro-competitive merger. We are doing this for X, Y, and Z reasons that will all help further the pro-competitive arguments that we're going to put forth in front of the regulators later on. And so, the big piece of advice that I give all my clients is that you should communicate to everybody in your organization, whether it's the CEO or a more junior sales member, that assume that all the documents that you create, whether that is a formal presentation, a text message, a chat, an email, they are discoverable and potentially could end up in a regulator's hands in the event that they're reviewing a proposed transaction.
Well, thank you, Dr. Ethel Fonseca and Danny Motter, for another outstanding contribution to our Mergernomics series with this excellent discussion on what we mean by killer acquisitions and how to analyze them. It was interesting to think about, just in the context of Facebook, Instagram to Meta Within, how much the thinking around competitive harm has changed in the past 10 years, and it remains to be seen whether it might shift again. To our listeners, be sure to subscribe on your podcast platform of choice and follow us on YouTube, and we'll see you next time on Trust and Trade.